Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today we're going to be discussing a recent Maryland Appellate Court decision, Estate of Brown v. Ward. In this decision, the court established, as a precursor to foreclosure, a loan licensing requirement for assignees or loan holders of specific residential mortgages. I'm Adam Friedman, managing partner at Friedman Vartolo, and joining me today is Friedman Vartolo General Counsel Guy Milone and Associate Rachel Kiefer. Rachel runs our Maryland foreclosure department, and Guy has extensive experience researching this specific decision and advising firm clients on the licensing requirements imposed. How's everybody doing today?
Awesome.
Doing
Thanks
very
for
well.
joining
Thank
us.
you. Doing great.
All right, let's jump right in. Does somebody want to walk us through the Estate of Brown v. Ward decision and the defense to foreclosure that it created?
Sure. So in this case, the court establishes a defense to the foreclosures that are taken out under covered loans under Subtitle 9 of the Maryland Commercial Code, where a loan holder did not possess the installment loan license or mortgage lender license.
Okay, so you mentioned there the term covered loan. Can you walk us through that? What do we mean? So we're saying that for certain covered loans, so for a certain specific subset of loans, there's a new defense or a new issue? Like what is that? What do we mean covered loans?
It's not necessarily a new defense so much as one that's been uncovered by defense counsel recently. So the requirements were always in place for a covered loan, which is a loan taken under Titles 9, 10, or 12 of the Commercial Code. And in order for those to be considered covered and subject to this requirement, that written election must be in the loan documents for the loans.
Right. That's correct. But that election is usually on the first or second page of the note, or it's in the loan agreement. And that's Subtitle 9 language is essentially what it's known as. And that language, I can read, it's right in the code. It's this loan is made under Subtitle 9, credit grantor revolving credit provisions of Title 12 of the Commercial Law Article of the Annotated Code of Maryland. So there's no mistaking it if it's covered or not. That language has to be, as we said, first or second page of the note or somewhere in the loan agreement.
Guy, I know that's where it generally is, and I know that's the general language. Like, could it be different language? Like, could it be on the last page and worded differently, or it just isn't normally, or how does it normally work?
If you read the code, strict reading would say the language has to be exactly correct. It's in quotes, it's statutory language. If it's not on the first or second page of the note, but contained in the documents, I would say that would be enforceable.
Okay. So are most loans covered? Like if this is creating a new issue for covered loans, are most loans covered loans in Maryland?
No, most loans are not covered loans. For example, the Freddie Mae and Freddie Mac are not. It's not in their standard language, nor the majority of deeds of trust and the accompanying notes would not have that language. It's a very specific section. It's really for consumer protection. That's why that language has to be in the document.
Okay. So now let's imagine we're evaluating a loan. The loan is a covered loan. Do all holders of covered loans need to be licensed, or how does that work?
Of course, there's going to be exceptions to the requirements. The list of exceptions are laid out in the code, and those include banking institutions and credit unions. Licensees under the consumer law, of course, are exempt. Sellers of goods or services that aren't engaged in the regular practice of making loans. Home improvement contractors would be exempt from licensing under the mortgage lender law. And a license that's held under Title 11, Subtitle 5, meaning that they are engaged solely in mortgage lending business, as in they're otherwise already licensed under mortgage lender law, those would also be exempt.
Okay. So we're saying this new defense applies to certain loans and only certain holders of these certain loans.
Right.
Yes.
How big of a problem is this? So let's say an investor or loan holder, right, confronts this problem, realizes, hey, you know what, I'm not licensed, I'm in the middle of a foreclosure, or I'm about to foreclose. How big of a risk of loss is this?
It's not a risk of loss if you're willing to obtain a license. So the issue is, if at the time you file the foreclosure, you don't have a license, it can be cured because subsequently you can obtain the license. But the court suggested that it would accept that you would go to the court and dismiss the foreclosure and without prejudice and get leave for the court to refile. So it's more of a delay issue, but again, you'd have to go through the licensing process.
Okay.
So it could be a substantial delay. And do you qualify? Just some investors may or some not. It's very specific, laid out what you have to do to apply for the license.
And I would add that it doesn't preclude your rights to collect regular payments on the loan or anything like that. This relates specifically to a foreclosure action and a defense to a foreclosure action. If a borrower wants to make an issue of a lender not holding the license when with their regular payments, they would have to file some sort of complaint or action against them in order to try to get them to get that license and enforce that. It's not an issue that just generally exists.
Right. I mean, look, I don't want to make light of the decision and what it imposes upon lenders, but when you think about it, and I'm highlighting this more so because clients ask about this a lot, right? We've had a lot of servicers require information. We've had different investors raise it as an issue. And when you think about it, what we're saying here is there are certain loans, then there are certain holders of certain loans that now have a new issue. And the issue is you may need to do something. You don't lose the loan. And it doesn't cover every loan. So again, not to make light of it, but I think it needs to be viewed this way, where it's not all encompassing. It only fits for certain situations and also is not fatal to the actual loan. Okay.
Yes, that's exactly correct.
Okay. All right. So to recap, there's a new defense to foreclosure for covered loans in Maryland, which are defined as loans with specific language referencing Subtitle 9 within the loan docs. If the loan holder does not fit into an exempt class and are not licensed, the borrower can raise the lack of a license as a defense. Second, Fannie and Freddie loans generally do not fit into this category, and a careful review of the loan documents is necessary. And third, finally, while this defense is a big deal and should be taken seriously, it is not a permanent impediment and can be cured by receiving a license prior to refiling. So thanks for joining Rachel, Guy, and I on the Weekly Friedman, your source for the most essential information in the default industry. If you have any questions, comments, or suggestions, please leave a comment below. Looking forward to seeing you next time.